briefly thank everyone for attending on what is turning out to be a beautiful fall day. I'm thrilled to see so many of you interested in this project and able to join us. And I'm looking forward to a lively discussion today. For those of you who don't know me, my name is Matthew Gluth. I'm an attorney advisor here at ACUS, and I'm staff counsel on our project on precedential decision making. Before we get going in earnest, I'm going to take two roles. The first will be the names of the committee members and their alternates. After each name is called, please say here so we can make sure your mics are working, and we'll go from there. First, Nadine.
Here.
Kent Barnett. He was a maybe. There's apparently something came up today, so hopefully he'll join us soon. Jack Bierman.
Here.
Michael Cole.
Here.
Adam Kress as alternate for Annika Cooper.
Here.
David Engstrom. Yep. Hopefully he'll pop on later. Hi Feldblum.
Here.
Dan Ho. Okay, hopefully he'll join us soon as well. Robert Lesnick. All right, Jeff Lubbers. Maybe we got going too early, Nadine. Danette Mincy. Okay. Let's see. David Pang is going to be alternate for Patrick Nagel, joining us at 2. But is Jeff Kirkwood here? Okay, not yet. Roxanne Rothschild. Oh.
I'm here.
Hey Jeff, would you like to? Hey Jeff, how you doing? Would you like to be alternate for Patrick until David arrives?
Sure, I'd be happy to.
Great. I think there's some questions from Social Security near the beginning of the document, so that'd be helpful for us.
Sure.
Roxanne Rothschild. Okay, and Russell Wheeler.
Here.
Wonderful.
And Jeff is here now, Lubbers.
Yes. Sorry.
Oh, great.
Sorry, I'm late.
Oh, no problem. Thanks for chiming in. Is anybody else from the Committee on Adjudication here that I have, whose name I have not called?
David Engstrom. I just got here. Sorry to arrive late.
Ah, great. Thanks.
Are you excluding the consultants, Matt? Because we're members of the committee as well.
No, I was going to put you in the unable to vote category. Okay. So I was going to get to you guys next. All right. Next, I'm going to call the names of other ACUS members and our consultants. And again, please say here if you're here so we can make sure your mic is working. I know Matt is here and his mic is working, so I'll just mark you down. Chris Walker.
Here.
And Melissa Wasserman.
Here.
Bill Funk.
Present.
And Lauren Elder Reed.
Good afternoon here.
Hey, thanks for joining us. Okay, are there any other ACUS members whose names I did not call? Okay, so with that, I'm going to
Rochelle Washington sitting in on behalf of the Departmental Appeals Board for Judge Tobias. I am sitting in on the call.
Great, thanks for letting me know. With that, I'm going to hand us over to Chairman Andrew Foyce, who was asked to say a few brief words before we get going on our work this afternoon. Andy?
Thanks very much, Matt, and Chairman Nadine. As some of you may have noticed, I wasn't able to make last week's committee meeting. So I wanted to take just a minute to say hello and welcome to the entire committee and everyone else who's here. Some of you I have not had a chance to meet and work with yet, but I look forward to that opportunity. Also, a special thank you to Nadine, who's experienced in talented hand has been evident throughout this process of meetings and the written product. A special thank you as well to our three consultants and to the staff of ACUS, Matthew Bluth, Jeremy, Alexandra, any of the others who've worked on it. It looked to me like you did good work last week at the first meeting, and you have a full agenda today. So I look forward to following and helping if I can. Thank you, Nadine.
Thank you so much, Andy. We're glad to have you join us today. And thanks for the kind words. This work only gets done by committee, obviously. So everybody here is committed to doing this good work. I'm going to run through some of the ground rules so that we can get started right away. Some of you know them, some of you don't, but I'm covering them. I am obligated to do so as committee chair. Please note that only ACUS members, which includes government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges, meaning that a non-ACUS member should write in the chat if you want to speak. To avoid background noise, please keep your microphone on mute and use the hand raise function or add a comment in the chat feature if you'd like to speak. I will call on you. You can unmute yourself and then remute yourself when you're done. Please, ACUS members, I would ask that you use the webcam. It's great to see people. It helps the dialogue. It helps the interaction. So please keep your cameras on if at all possible. Regarding attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. So time permitting, I will call on those attendees at appropriate points, and we will presume that the committee members consent to that, absent their raising an objection. If any such participant would like to speak, again, please indicate in the chat feature or by using the hand raise feature and wait to speak until I call on you. You can then unmute yourself and remute yourself when you're done. For all participants, please use the chat function only to indicate when you would like to speak. Please do not hold any sidebar discussions or put substantive comments in the chat feature. And only members of the Adjudication Committee have a vote, which we hope to take today. Please do not vote unless you are a member of the committee. We have a list in case you're not sure whether you're permitted to vote. All three consultants, as Matt noted, are members of the Adjudication Committee, and they will be participating today solely in their capacities as consultants. So they will not be voting. I think that covers it. Matt, did I miss anything?
I think that's it.
Great. So if we can get the draft up. My plan is to start with the preamble, since we have not looked at that yet. We've been through the recommendations at the last meeting. So it would be great if we could start with that. And we have already gotten several comments and suggestions from different members of the committee. I think largely Russell and Jeff. But we get to start right at the top with the title. Russell has a suggestion about the title. I think you can read the comment that Matt has put in here. But if Russell, if you would like to speak about the title in any way, let me know.
No, just to summarize what I said in the comment, it seems to me that the recommendation is much broader than how to make precedential decisions, which is how I would read it. And I suggested an alternative title, which may not be any good. I said Presidential Decisions and Agency Adjudication Policies and Procedures. I don't know if that's the best way to do it. I think the consultants might have a better idea, the committee members, but I thought it was too limiting a title.
Any thoughts on that from the consultants?
This is Matt. I don't see the title as limiting. I just don't see that. I also
is the hotel room. It's.
I also this strikes me as being in accord with most other ACUS, the titles of most other ACUS recommendations.
Thanks, Matt. Any thoughts from?
I would agree with that.
That's Chris. Okay. Thank you, Chris. Melissa, anything further?
No, nothing further.
Anybody from the committee have thoughts on whether to leave it as is or add, revise in some way?
In light of Matt's comment, I'll withdraw the suggestion. If they think it's good enough, that's fine for me.
Great. Okay, we will move on then. We have some changes in the first paragraph, I think suggested by Jeff initially. I don't know if Jeff wants to speak to that. I think it's pretty self-evident that essentially we're calling out what we're already citing to in the footnote. So whether we need to say it above the line as well, I think is Jeff's concern or question.
Yeah, I didn't think it was necessary since the footnote makes clear that these are addressed. And as to the next line, I just wanted to move up legislative and non-legislative rules because I thought they were more important than the others.
Got it. Any comments on that from anybody? Okay, great. I think the first paragraph we can, unless anybody has anything else that they haven't already raised. Jack?
Yeah, I was a little unclear. Are we going through only the things that were comments, or is the entire text open for discussion?
The entire text, I should have said that initially.
Okay,
I was going to the comments that were already provided, but
Because
if there's anything
sometimes
on the,
we do it.
Yeah.
Sometimes we go through all the comments first
Yep.
and then go back. So I wasn't sure. So I had a suggestion in the first paragraph. I don't like the way that the when adjudicating cases falls at the end of the first sentence. It seems like kind of hangs there. So I thought maybe moving that up to the beginning, when adjudicating cases, agencies use many different mechanisms and so on. I thought that read better. I'm not, that's my usual shtick. I don't know if other people agree with that.
any comments? Bill?
Well, that's not the way I read that sentence. I read that the agencies use many different mechanisms to formulate policy. Not when adjudicating cases they do this. The adjudicating cases, I thought, referred to ensure consistency, predictability, and uniformity when adjudicating cases.
Well, then you would take the and out from before uniformity and put and when adjudicating cases. What you're saying is a different meaning than I think the authors intended.
No, it's all ensure consistency, predictability, and uniformity when adjudicating cases. That's the phrase.
So the idea being that when adjudicating cases is only modifying that last phrase and not the formulate policy, enhance efficiency.
Correct. Agencies, because then we say, they use legislative rules, right? In the next sentence, we say one of the ways they do this is by legislative rules.
Yeah.
I mean, that was, I didn't like the first sentence because it started off by saying agencies use many mechanisms to formulate policy, and then it ends up, we're talking about adjudication in this recommendation. And although some agencies do use adjudication to make policy, I think that's more the minority than the majority. So I thought it was, and maybe that's why some people have had difficulty reading what I think was written there.
Okay. Well, now I'm sort of like, I'm not sure what I think, but I'm in agreement with Bill that it's confusing, since now I'm confused.
Hi.
So this is helpful because it wasn't something that focused on, and it is really important. And I would like to hear what the folks who wrote it intended. I think based on what's in this recommendation, we are saying that agencies use, don't put this in yet, let me just, but agencies use different mechanisms to ensure consistency, predictability, and uniformity when adjudicating cases, right? I'm not sure about enhanced efficiency. They also use many different mechanisms to formulate policy. These include appellate review, legislative, non-legislative, right? So the whole point about this is agencies are formulating policy when they adjudicate cases. And so that probably should be made clear, right? Because all agencies have some mechanisms to ensure consistency, predictability, and uniformity when adjudicating cases. I mean, they may work or not, but they all have something. And the point about this recommendation is that case adjudication is also one mechanism of formulating policy. And that's why having a clarity around precedential decisions makes sense. So again, I wasn't trying to do language yet. I was just putting forward what I think we're doing and to see whether this is what the authors of that sentence also meant to convey.
Before I turn to Bill, does anybody who worked on the draft want to add anything here, or so we get clarity on the meaning? Chris?
I didn't work on the draft as much. I made a little bit, but I think our idea, at least in the report, and it's not worded. I agree that the prior version wasn't worded right, but I think we really do mean that all of these include is not just to make policy, it's also to enhance efficiency, ensure consistency, predictability, uniformity. And so we view those mechanisms, like we view precedential decision making as one more tool in the toolkit for advancing all of those goals. So I don't know how we word it, but I think that's what we were trying to get out of the report.
Bill, did you have some language?
No, I mean, I agree with what I read it the way Chris just said, which was that this idea for precedential decision making in our recommendations are not just with respect to because it formulates policy, but it's also because it enhances efficiency and ensures consistency, predictability, and uniformity when adjudicating cases. That precedential decision making does all of those things.
Okay. Hi.
Just to say that I agree with that, just in case, I was just trying to work with that first sentence, but I think that what Chris said is the way I understand this recommendation. So just to align myself with that for when we try to do some language.
Jack.
I think that if I'm understanding this correctly, I would propose the following to substitute for the entire first paragraph and the first sentence of the second paragraph. I would recommend, I'm suggesting agencies use many different mechanisms to ensure consistency, predictability, and uniformity when adjudicating cases, including designating some or all of their appellate decisions as precedential. I don't think we need to mention rulemaking and stuff, that sort of thing in this, because that's not the topic of this recommendation. So, and then just take out everything other than, and then start, the second sentence would be a definition of when a decision is precedential.
Can you repeat the including phrase, including when designating, I think.
Including designating some or all of their appellate decisions as precedential.
And that would replace the first sentence?
It would replace everything up until the second sentence of the second paragraph.
Got it. Thank you. Matt's got it highlighted here. Thank you. Let's go to Jeff.
I don't oppose that, but maybe we could still preserve the footnote by putting in a little introduction to the footnote saying that agencies also no, not in the footnote, in the footnote itself. Just also use other techniques such as appellate review, legislative, et cetera, put that all in the footnote, and then it wouldn't disrupt the flow in the recommendation. I don't know if Jack agrees with that, but
Let's hold that thought. Chris, did you have a comment about? No, you're still up. Okay, Hi.
I mean, I guess just real quickly.
No, go ahead, Chris.
I mean, I kind of liked a little bit more introduction than Jack does, but I don't have a strong preference.
Okay. Hi.
Well, my comment might be along those. So I like that, except now we've lost the point that those cases also sometimes set policy, and certainly I know at EOC is a major way we did it. We use federal sector cases. So maybe what you say, agencies use, I don't think you need many. Agencies use different mechanisms to ensure consistency, predictability, and uniformity when adjudicating cases, including designating some or all of their appellate decisions as precedential. Precedential agency decisions can also set policy for the agency, right? Because that's, to me, part of why this recommendation is so important.
Lauren? No hand. Okay. Any reactions to this? I see we have lost the phrase enhance efficiency. That's the one little piece out of that original sentence that we don't have anymore.
Sorry, I'm a mess on my controls. I was trying to raise my hand. I was not trying to applaud, and the face I made was because I hit the wrong button.
Got it.
So the second sentence there concerns me only from the standpoint of, and I would really welcome others' thoughts on this, the ability to set policy through a decision. So I recognize it obviously sets a precedent by which others must follow, but policy, guidance, those are really loaded terms these days, following executive orders and like recent case, West Virginia EPA regarding regulations and like authority to do. So I'm a little bit concerned about where we might be going with actually overtly setting policy through a decision.
Chris, did you have a comment about that line?
Yeah, I mean, I do think a lot of agencies do set policy through precedential decision making, but I wondered if we're going to do that. I wonder if to kind of water it down a little bit, or not water it down, but we could also say something like presidential agency decisions can also set policy for the agency as well as communicate to the public and court or something like that, to talk about the public communication aspect of it.
Which I think
I'm
we
not sure
do.
the right word, but like that was one of the reasons we had presidential decision making that came from the agencies was, this is a way from for the agency to emphasize, to communicate to the public, to courts, what, important decisions or important something that the agency, I don't know the exact wording, but that might kind of make it seem like it's not just about policy making, that it's also about kind of broader communication efforts.
We do have some of that in the second paragraph of the preamble. So we may be looking at ways to kind of blend these topics. Let's see. Let's go to Roxanne, a fresh new voice.
Sure. I was just going to say that I liked the fact that the original language referred to rulemaking as a part of the precedential decision making. And the reason I liked it is because that might not be something people usually think about. But when, like, for example, when my agency does rulemaking, sure, we do procedural at times, which isn't really at issue. But when we do substantive rulemaking, that then directly informs our precedential decision making going forward once that final rule is published. And that's why we do the rulemaking, because we think that there's an area of the law, not to speak to what the board members are doing all the time, but there's an area of law that they feel needs to be clarified on a broader scope. And so we'll issue a rule on joint employer, we'll issue a rule on some other topic. And then from that point forward, our precedential decisions comport with what the rule said. So it is used as a part of the decision making and for the agency.
So you just to clarify, you would retain the language as it was, the original sentence.
I like that it had that in there, and because the way it's throwing in the footnote, the way it's phrased now makes it sound like, okay, there's precedential decision making and then there's rulemaking totally separate. Maybe that's true for some agencies, but not for mine.
Okay, thank you. Hi.
So I want to completely agree with what Lauren just said. And what I was trying to do is not lose the idea of formulating policy. You know, so sort of that's to formulate policy was the term used rather than to set policy. So I do think it may be worth going back to original language, but addressing the particular issue that came up about the confusion about when adjudicating cases. You know what I mean? So, for example, it's almost like, just looking at this, agencies use different mechanisms. I don't need many there either. Use different mechanisms to formulate policy, enhance efficiency, and ensure consistency, predictability, and uniformity, maybe with regard to their legal positions, something like that. Just put it in brackets because I'm not sure. The legal positions. Okay. These include, and I don't know if you want to say adjudicating cases or whether that's the same as appellate review. So just do a slash between those two, because I don't, you know, adjudicating cases / policy, appellate review, legislative, non-legislative rules, etc. You know, the only reason, by the way, to keep legislative and non-legislative at the end is the appellate review, the quality assurance programs, the aggregate decision-making, those are all connected to adjudicating cases. And then, as Lauren said, sometimes it's when you realize, you know what, we should just do a rule or guidance, that is sort of chronologically sometimes at the end. So I guess what I'm suggesting is that we go back to the original language, but make some changes to address the confusion that had arisen, which I think was legitimate.
Jeremy, did you, Jeremy.
Not directly related to Chai's point, but I think one problem here is, and it's not unique to this recommendation, and I think the report makes the point really well, is that no one really knows what policy means. Lots of people define policy very differently to mean very different things. For a lot of people, interstitial decision-making isn't necessarily making policy, it's just the act of interpretation. So it might be useful, instead of using the word policy, which is quite loaded, to say something like agencies can also use precedential decisions to communicate how they interpret legal requirements or intend to exercise discretionary authority, which I think probably makes the point without using a vague and loaded word like policy.
Do you want to repeat that?
Sure.
Yeah, Jeremy, where would you like me to add that? Is that to replace this set policy for the agency?
Yes. You might say that whole sentence, you could say agencies can also use precedential decisions or decision-making to communicate how they interpret legal requirements or intend to exercise discretionary authority.
Thanks, Jeremy. Jack?
I guess I'm gonna give it one more try because I've rewritten my rewrite, and I'm listening to, as I listen to this discussion, I'm even more convinced that we need to isolate our attention on precedential decision making in the text and only talk about other methods in the footnote. Because I understood Roxanne's comment really clearly, and I think my understanding is, and maybe I'm wrong about this, that precedential decision making is an alternative to rulemaking. That is, an agency, if an agency makes a rule, then of course all adjudicators within that agency are bound to follow that rule when they adjudicate cases. And even the agency heads that are required to, unless they repeal the rule somehow. Whereas, so that's one method, and that's why the other methods belong in the footnote, if they belong in here at all. Whereas the method we're zeroing in on here is precedential decision making in the course of adjudication. And I do have a rewrite based on this discussion, because I inadvertently left efficiency out, and now I understand a little bit more about why maybe we need to mention policy in this also. So let me throw this one out there and see what people think about this. Agencies use many different mechanisms to establish and communicate agency policy and to assure efficiency, consistency, predictability, and uniformity when adjudicating cases, including designating some or all of their appellate decisions as precedential.
Can you go back, Jack? Slow down.
Okay.
Can you see the screen?
Comma, including including designating some or all
Some
of
or
their
all.
appellate decisions as precedential.
Okay.
And then in the footnote, I would say the other mechanisms, these other mechanisms include, and then up till as, appellate review, legislative and non-legislative rules. I would say rulemaking rather than rules, but that's a preference. Quality assurance programs, aggregate decision-making, and declaratory orders. I think that captures the scope of this and everything we want to talk about, and it does it in an economy of language, which is always, and I think it also is a good opening to this, to what the topic of this is.
So that would replace these lines 4 through 7. Sorry, go back up. It would replace all of that. Okay.
It's just replacing everything that I was trying to replace before, up till the second sentence of the original second paragraph.
But retaining the footnote. Okay.
Yes.
Thank you. Lauren?
Sure. So recognizing that all of our decision-making and therefore precedent decision determinations vary among agencies, I do still carry the concern related to policy, especially actually after hearing Jeremy's alternative language that I think captured what I was trying to say so eloquently. I am uncomfortable with the idea that our Executive Office for Immigration Review within the Justice Department, that we are communicating agency policy through our board precedent decisions. I think rather we are applying existing policy. The cases that are overturned in the circuits tend to be those that either do not properly represent policy as applied or are a point of contention, perhaps split circuits and things of that nature. So yeah, I don't think that for us it captures the precision that I would like. However, I do recognize that it's saying it is but one mechanism and we are but one agency. So I wouldn't go so far as to say I think it's overall problematic, but to the extent others relate and are concerned with that precision, that's my piece.
Okay, we're going to try to call this a day soon here. Hi.
Yeah, I think maybe we can, because I like this redo, but I just want to agree again with Lauren. Jeremy, I really liked your alternative formulation, if you can remember it, because that's the one piece I didn't want to lose. You know, it's a way of communicating the agency's position on legal issues, you know, in the statutes they're implementing. So I think if we do that, then I actually am comfortable. I think this is a better sentence.
Can we move Jeremy's proposal up after the new Jack Bierman first sentence?
No, I think it's to substitute for establish and communicate. They use different mechanisms to communicate how they interpret legal requirements or intend to exercise. You know what I mean? But that's too long. Maybe you can just say, I don't know. I don't know. I didn't but you don't want to use precedential decision when adjudicating, including then communicate.
So it would say agencies use many different mechanisms to communicate how they interpret legal requirements or intend to exercise. Yeah, I don't think that's going to fit in there.
You can, no, but you don't need the how to exercise discretionary authority. I mean, I think Lauren's point and the way I'm agreeing is instead of saying policy, establish and communicating policy, what agencies are doing is establishing and communicating
how they
establish and communicate how they interpret legal requirements in the statutes they implement, right? And to ensure efficiency, blah, blah, blah. Oh, but you know what? It's still, what a mess. Sorry.
I blame Jack.
Well, it was a good point.
No, it is.
I don't know. I don't know if someone can maybe work on this while we go to other sections and then come back, because I think we're all agreed on the concepts and we're just struggling a little bit on how to do
I'm going
it.
to give Roxanne one shot at this, and then we will move on. Right, we can't hear you.
In terms of what I was editing, I thought that if you left Jeremy's sentence the way it is at the end, not deleting it, and then in Jack's new language, you just say agencies use many different mechanisms to, then get rid of establish and communicate agency policy to, get rid of the second two as well. I don't know if this makes it work better, but you could make this work, like in putting all of Jeremy's statement back in. Thought. Yeah. And I'm happy to let other people edit this.
Oh, no, that would stay in. Yeah. Yeah. I think we put a pin in that. I actually like that because I think it melds Jack's original concerns with, I think, some great language that Jeremy came up with and takes into account Hai and Lauren's concerns as well. So why don't we leave that first paragraph, delete? Can we delete? Yeah, you're reading my mind, Matt. Okay. And then the footnote is still there. Great. Okay. So we're jumping all the way now to, it's line 19 on the screen. So let's go through. I want to be clear, since Jack raised it, that we can go through the comments and the edits that are specifically flagged here, but that does not mean that we're not open to obviously discussing the entire paragraph. So we have the suggestion from Jeff to indicate below the agency head level. I actually had a question on that, but I'll let Jeff explain his thoughts. Or they're self-explanatory.
Well, we're talking about an agency adjudicator that has to follow its holding, and if it's the agency head, they don't necessarily have to follow the holding. So I was trying to say below the agency head level. Now I realize that could be just the hearing level person, ALJ, AJ, but it also could be, in the case of the Department of Justice, BIA, because there's an intermediate stage in EOIR. So I was trying to just exclude the thought that agency heads had to follow their previous holdings.
Which I wish we could say. Roxanne?
Maybe we could put that in a footnote or something, because at least at my agency, our agency heads who are also adjudicators are bound by precedent. And we have plenty of footnotes where a board member will say, well, I don't like this, but I'm bound by precedent unless the majority is willing to overturn it. And so they are bound until they eventually get enough people to agree to change it.
I had the same reaction. Bill?
Well, that's, I think, Jeff's point, is they can overrule it, right? That is whoever
Not by
made
themselves.
Yeah, but that's the point. Whoever made the precedent, the individual didn't make the precedent either. Whoever made the precedent is not bound by the precedent. They can overrule it. Anybody below or individual members themselves are bound, but the people below, but not the person who made the person or entity that made the precedential decision. That entity or person can always overrule it. Correct, Jeff? That's your point, right?
Yes, but I think Roxanne's point was something I didn't consider, which is the individual board member might feel that, they're not, the individual board member is not the agency head in the sense that Bill and I were talking about it. But so it's pretty complicated to put into a couple words.
That's right. And that's why I think the idea of putting the idea in a footnote, explaining that the difference between vertical precedent and horizontal precedent can be something that could be explained in the footnote.
Jack?
Okay, so I think this can also be handled by saying less and saying it a little more clearly. Here's what I think we should do, and especially given in light of Roxanne's comment, which is accurate, which is agency heads are bound by their own precedents until they overrule them, unless they're distinguishable. So I would say, because otherwise that's the whole point of this. Otherwise they can be inconsistent. So I would say a decision is precedential, but an agency adjudicator must follow its holding in subsequent cases unless the precedent is distinguishable or until it is overruled. I think some of that other language is a little superfluous. I don't know, usually unrelated doesn't, I don't know why we would need to say that. And the other stuff about must answer it in the same way, I mean, that's just inherent in the nature of precedent. If you don't understand precedent, you really don't have any business reading this recommendation and doing anything with it. So that's
So
how
that combines those two sentences that are there now. Jeff, does that address your concern?
Yes.
Great. Kent. Hi, Kent.
Hello. One small thing, but I can't tell if it helps a little bit to Roxanne's point too, is changing its to the agency's holding, because right now I think its is referring back to the agency adjudicator, I think, which seems odd in and of itself. But if we're clarifying that the holding comes from the agency, then it makes sense that one adjudicator, even if they're a multi-member body, is bound by the agency's holding.
I think it may have meant decisions holding, but
I see.
Any reaction to agencies? I get that the its is probably not entirely clear there. Jack, you still have your hand up. Did you have a comment on that? Nope. Okay. Any objection to leaving it as agencies? Roxanne?
I would just say I agree with you, Nadine, that I took the its to mean the decision.
Okay. So we should say the decisions holding in subsequent cases. Okay. All right. Sold. Anything? We're definitely correcting that typo. Russell, your comment was the one I loved the best. A lot of people caught that one.
Yeah, I tell you, that actually is a word, though, I found out, but
I'll have to look it up. It doesn't ring a bell for me.
I forgot what it means. My concern more was that I think there's also a grammatical problem. Precedential decision in the singular should probably be plural or decision-making or something.
Yeah, I suggested it be plural.
Yeah.
Yeah, yeah. And then while we're on this, and then the antecedent it, I thought was unclear as shown on what is now line 27. I would just repeat the phrase from above. At least I stumbled over it. So to make clear what it is.
I think that makes sense. And we have an and there. Yeah. Okay. Anything further on? Can we scroll down? Do we have any other? Yeah. Okay. On those lines there. I'd like to Bill's suggestion about important. We shouldn't characterize one way or the other. I think that was Bill's point there. Okay. So let's go to 30. We had a comment here from SSA. Y'all can read it there. Matt, did we have somebody here?
Jeff Kirkwood is here from Social Security. Stacy Cole was unfortunately unable to make it today.
I think the concern here is that maybe this is a little too absolute. I don't know, maybe I'm simplifying it too much, but if.
Isn't the concern that it might make them look bad for not doing it, and they're
calling them out?
Yeah, calling them out when there's a good reason that they don't do it.
Right, and in your prior reports, you laid out the reasons why precedential decision making just doesn't work for us. The non-adversarial nature, the numerous decisions. And, you know, we have, as an organization, have gone away from it for good reason and gone to a much more cooperative among our policy component, our initial hearing component, our general counsel, and us to come up with these with non-adjudication Social Security rulings that reflect that they're signed by the agency head and are receive deference in courts and are complied with by our adjudicators who do 600,000 cases in a year. So we just wanted to be sure that that's sort of an exception for our type of adjudication would be reflected in the document.
I'm going to ask Matt. I see your hand up. It would be helpful to hear from you.
Yeah, I certainly understand Social Security's concern. I'm not sure that I agree that the cases are so fact specific that they don't lend themselves to precedential decision making. SSA obviously uses other mechanisms here. The only thing I would caution here in terms of what the committee does is there are prior recommendations of ACUS. I would be a little bit careful about saying that having a categorical statement to the effect that Social Security decision-making doesn't lend itself to the use of precedential decision-making, because there are prior ACUS recommendations. They're cited in the report in a rather lengthy footnote. They do refer to SSA. They do recommend to some extent, they do recommend that SSA, and they're not recent recommendations, they're a little bit older, but they do recommend that that SSA place greater reliance on precedential decision, the use of precedents. Now, that may beg the question what exactly ACUS meant by precedents in those recommendations. I don't have them in front of me. I just saw the comment, but I just do want to make the committee aware that there are these prior recommendations that refer to SSA making greater use of precedential decision making.
Thank you. Let's go to Bill. I think your hand was up first.
I have a simple suggestion, which is to delete that phrase with the exception of Social Security Administration, Department of Veteran Affairs, and just say, instead of almost every, say most adjudicating agencies use. Most adjudicating agencies use some form of agencies. Plural.
I think that was Roxanne's suggestion. I see she dropped off. Hi, did you have any thoughts about effects?
That was exactly going to be mine, although, yeah, that was, I had slightly different, but this achieves the same goal.
Most agencies use single.
And Jack, I think the same. Okay. Any further comment on that? Jack?
I had one more thing about this paragraph. I don't know, is it appropriate to go there now?
Sure.
So the next sentence where it says others treat only some appellate decisions the following. In either case, the presidential decisions come from an agency head, I would say, or heads, and take out the parenthetical. And then down a couple lines below there where it says adjudicators exercising the agency head's authority, I would change that to agency's authority. Because I think agency and agency heads is synonymous, the way it's treated in many statutes and rules. When you say you're exercising the agency's authority, that means that the head of the agency, or like the multi-member board or whatever. So I think that's just a clearer way, simpler way of saying that.
Matt, did you have further comment on this? Your hand is still up. Matt?
I didn't, and I will take it down. I apologize.
That's okay. Lauren?
Thank you. Just that within EOIR, we would not consider the board members agency heads in sort of the traditional way of looking at it. There's certainly senior leaders in the agency, but I was more comfortable with the parenthetical.
Okay. I had the same thought. Adam?
I just want to confirm that the consultants studied 20 adjudicating agencies, but we're all comfortable just saying most adjudicating agencies, not qualifying it to most of the adjudicating agencies considered by the committee in preparing this recommendation, or some qualifier like that. Maybe that's not necessary if the 20, really, we're comfortable that really covers, almost all. But my understanding was that it was really looking at the like the largest, I guess, adjudication systems.
Okay, let's deal with that first, and then we'll go back to the parenthetical question. Matt or Chris or Melissa on saying most, given the report's coverage of specific agencies. Are you comfortable with that? Any thoughts? Matt?
I am comfortable with it. I guess it does raise the question, what adjudications are covered by this recommendation? There are, in prior ACUS recommendations, sometimes ACUS has identified the domain of adjudications that's covered. Maybe it's probably implicit here. I think it's okay. Jeremy, Melissa and Chris may have thoughts here. Jeremy may have some thoughts too, but I'm comfortable with the statement.
Great.
Yeah, I am as well.
Jeremy, did you want to weigh in, or are we good?
I can. I mean, Adam, I hear your concern, because obviously, some of the biggest adjudication programs defined broadly are things like passport adjudication, where things like precedential decision making is almost certainly absent. I think when ACUS says adjudicating agencies, people tend to take that as systems in which there are hearings and some sort of formalized trial-like process, but that's probably not obvious on the face of this sentence. Would using the word many satisfy everyone?
Jeremy, can I just add one, or Nadine, I just add one thing to what Jeremy said? There are, what I was trying to refer to when I was talking about sort of the domain adjudications, which is a vague phrase, as Jeremy points out, basically, there are prior recommendations where in the adjudication context where ACUS has made pretty clear that it's talking about adjudications that whose hearing level, whose hearings are either formal adjudications under the APA or are trial-like informal adjudications under the APA, which is to say that they're at very least the hearings are an exclusive record hearing is legally required by statute, executive order, regulation, so forth and so on. There are prior adjudication recommendations that have identified sort of the domain of adjudications with which the recommendations deal. I think that appellate systems, of which this is sort of a child, did not do that, but I don't recall that in particular offhand. Maybe that's something to look at if another draft's going to be produced here.
I'd say we stick with many, and maybe we can make a note to check that, Jeremy.
Sure.
You can also drop a footnote if you need it.
Okay. Let's go back to line 34 in terms of retaining the parenthetical.
I was the one who suggested the parenthetical, and the reason I did was I think that, instead of saying or, in some cases, a multi-member commission or board. I mean, I think that because those are the agency heads, as has been pointed out, it's the board that's the agency head at the NLRB. So come from an agency head, in some case, parentheses, in some cases, a multi-member commission or board. And I would take out or heads. I don't think that's, so I guess I disagree with Jack on this, but especially in view of our previous conversation.
I think Lauren raised the concern here and I share her concern. I think this is probably the better way to go, Lauren.
It's piddly, but the or is really important because I think without it, it's still implying that the board is in fact an agency head.
The board is an agency head.
I would,
Which
I would
board?
submit that is not the case.
Which
at
board?
UIR.
NLRB?
No, I'm with UIR, so I'd be referring to the Board of Immigration Appeals.
Oh, okay. Well, so.
And again, they are leaders. I don't mean to take away. I mean, they're incredible legal minds who do hard work. But certainly, we have a director to whom they are accountable.
I get your concern now, but
Thank you,
Jeremy.
Yeah, I would just point to what follows after that, which is officers exercising delegated review authority, other things there that I think would probably cover the BIA more accurately. Agency head was not meant to include things like BIA. In that case, it would be the AG.
Okay, I think we're good on the rest of this paragraph.
we're keeping in or?
Yes.
That's what I was going to speak to. I think or, but why do we need board? Because even if something is called a board, like the NLRB, I think one would consider that a multi-member. Okay, no, I withdraw.
Okay.
I think, yeah, okay.
I mean, I think the word or is confusing there because I understand Lauren's point that the BIA is not an agency head, but that's the Attorney General is the agency head there.
most certainly. And if we're considering that the board the fact that the board is acting under the authority of the Attorney General's delegation to them, then I think that's fine. That seems a little nuanced to me without a footnote. To recognize that that's the fact, because the Attorney General, though, can certify decisions to himself, the director of UIR actually cannot adjudicate, and so it's just a really unique comparison. I wonder do we need? What is the reason for needing to discuss this point? I'm trying to consume while talking. I guess the fact that precedential decisions can come from an agency head.
That would be adding the word. I was thinking the same thing.
I'm thinking in my head.
No, I was thinking the same thing. Are we trying to capture the entire universe? Or are we just pointing out some possibilities? So you could say precedential decisions can come from an agency head.
What about multi-member agencies? Or a multi-member agency, take out commissioner board, say multi-member agency.
Yeah, I think this is the problem, is the kind of board that's not the heads of the agency, like the Bureau of Immigration Appeals.
Well, in my agency as well, we have an agency head. And when we issue decisions, it's issued by the full commission, which is a multi-member commission, but the multi-member commission is not the agency head.
No.
May I make a suggestion to address this exact point?
Go ahead.
Okay, so I think that the problem is, again, we can remove language and we can make it clear. So in either case, precedential decisions can come from an agency head or heads, comma, and then delete everything down to delete the parenthetical adjudicator, and then keep the next sentence. Adjudicators exercising the agents, and again, agency's authority to review hearing level decisions. Adjudicators who review hearing level decisions, which that captures the Board of Immigration Appeals, right? Because it says adjudicators who review hearing level decisions, but whose decisions are subject to discretionary agency head review. Is that accurate on those? That can't the Attorney General review the Bureau? Is the Bureau of Immigration Affairs in Justice now or Homeland Security? I can't.
Correct. The Board of Immigration Appeals is part of Justice, and the general can certify decisions to himself.
I think if we take out the parenthetical, the whole thing is clear and captures everything we're talking about. Am I correct about that?
depending on how the board is described later and making sure that agency refers to DOJ and not our director, because that's actually a very important piece that the director does not adjudicate decisions. Then I agree that removing the parenthetical and leaving the rest as is works. I do like can still.
I do too. Anybody else? All right, so let's go down to 40 through 46. This is just kind of laying out what's to follow. 47 through 53. We had a comment here from Russell. I'll go to Adam first and then we can deal with Russell's comment.
Sure. On 47 to 48, I guess it's 48. It says for all agencies to use some form of presidential decision making, the recommendation identifies best practice for designating decisions as presidential. Is the word there, is designating the right word there, or is it identifying? And the reason I ask is because it seems like the prior paragraph gets to the recommendations and like, I think it's like 4 through 9 that talk about the procedures that are used to designate decisions as presidential. And it seems like this sentence talks more about the recommendations that I think it's like 10 through, I want to say 15, of which 10, 11 talk about how do you, it's really best practices for kind of like labeling decisions as presidential. And then maybe the remaining recommendations talk about making those decisions available to the public. So it seemed, when I read it, I was confused. I thought maybe this was getting at the same thing the prior paragraph got at, but I thought the idea was to get at something different.
Any thoughts on that? I think it may flow from some of the language we use in the recommendations. So I think we can leave it as you've suggested. And if we need to reconcile, we can. Let's go to Russell's comment. I think the concern here was whether or not there were 2 requirements from the FOIA
I
that
just didn't know. I noticed the statute just cites one section, but it seemed, I just had a hard time reading that sentence. If it's either one a requirement or 2, it seems to me you got to do something to make a little clear that there appear to be 2 separate or two somewhat separate items. One, they post their websites all final orders, and second, some things they can't do. If that's a single statutory recommendation, then we couldn't change it, but is there any way to just make it a little easier to read? Or maybe I'm the only one who stumbled over it, and if that's the case, I'll withdraw the suggestion.
Matt or Jeremy, do you have a sense of whether?
Why not make it plural?
I think plural is fine.
Yeah, okay.
And then, as I said, I would say, one requirement is the other requirement, if it's plural, one requirement is that agencies post, the other requirement is that agencies generally mailing. Again, if it's just my obtuseness in reading this, I don't want to push it, but when I stumble over things several times, I raise it.
It's not the other, it's another.
That's fine.
Okay, I think we're good on that. Anything on the last paragraph? I think we had a comment there also from Russell.
No, that was for me. Just
Oh, Jeff,
punctuation,
sorry.
just a
So sorry.
punctuation suggestion.
Yeah, okay, commas. We like commas. Anything further on the preamble? Great. All right, we've been through the recommendation. We have some edits that were done by staff. We also have some comments to consider as well. We'll start at the top with paragraph 1.
This is kind of the same ground we've just been covering, but an agency adjudicator below the agency head level.
And I think our fix the first time was to take it out.
What did we say in the preamble?
Yeah.
We just talked about precedents rather than people.
Yeah, all the way up, I think, Matt. Right there. Yeah,
I
I'm
believe
not sure.
We
Yeah,
did not include the below the agency head level because we
We did not.
concluded that agency heads would also have to follow it unless they distinguished or overruled it.
Right.
But we added that extra language there.
No, I don't think,
No.
you mean in the recommendation?
In the preamble,
Mm,
right underneath there. Unless the precedent is distinguishable or until it is overruled.
okay.
I think also we took out the unrelated cases.
Yes, we did.
Right?
Yeah. Why don't we just use the same language?
You can just copy that over. Okay. David?
So this is maybe just stylistic, but I frankly found paragraph 1 to be kind of tough sledding. It's awfully long, and there are quite a few clauses set off by commas. And so, if folks agree with me, I guess I would recommend one of two things. One, we might consider dropping the commas after decisions and opinion. It's not clear to me why that clause needs to be set off with commas, which might make it read a little more clearly to my mind. Alternatively, if we want to define precedential, maybe we put that in a separate sentence. Maybe we just say here, comma, precedential means, and have that be a second standalone sentence.
I mean, the one thought is that we've kind of already covered this territory in the preamble. So is it understood what we mean by precedential? Do we need to repeat it again? I bet Hi will have a thought on that with implementation, but I think, David, your suggestion was to drop the comma after decisions and the comma before the as.
Yeah, that's right. Exactly.
Is there a reason to repeat the meaning clause when we've already said it above?
Some people don't read preambles.
Ah, they should. Hi.
Yeah, one of the things I felt when I read this is this was a really good document in terms of implementation. It was short, it was clear. I think in terms of implementation, folks will read the preamble. And in fact, that's what we want to encourage. So I'd rather, I know from ACUS precedent or ACUS, tradition, you sort of think that, but I think that don't expect agency folks to read the whole report, but absolutely expect them to read the preamble and have that influence their understanding of the recommendation. So that's just my gut feeling.
So you would take the language after precedential out? I do think when we reviewed this and added it, I think we didn't have the preamble obviously before us yet. So we kind of know what we mean now by precedential.
Right. Actually, just looking at this, I don't think this is a lot of language. So let's see, should consider as precedential meaning except unless and distinguish or it is overruled.
It's the language we used above in the preamble. Exactly. We just copied.
Yeah. That I think is fine to keep in, because again, for implementation, a little bit of repetition is fine. So I have no problem with adding this particular thing. I was just sort of
generally,
generally, let's write the preamble in a way that they will read it and start to expect that.
Jack, did you have a thought on this language? No. Jeremy.
All right. So since the question of ACUS precedent came up, I'll jump in. There's usually a preference that recommendations be self-contained. I guess the question here is whether precedential is so obvious in its intention that you don't need to define it again here, or whether you think that to make these recommendations self-contained, a definition is necessary to include in recommendation 1. So I think that's really the question.
Thank you for distilling that. That's very helpful. Jack.
Yeah, I agree with Jeremy. I think we should keep the definition in, but I also had another issue on paragraph 1, but I don't want to jump into that until we're resolved with this. I mean, what do you think?
Well,
Nadine?
give me 1 second. Any further comment on taking it out? We got the commas out, so maybe that helps with David's concern. We have added a little more language, but at least we're being consistent. And as Hai said, maybe repetition is helpful. Okay, Jack, go ahead.
Okay, so there's the clause other than summary dispositions unaccompanied by opinion. That really is a backwards way of, or a cryptic way of saying that we're saying that they shouldn't treat those kind of dispositions as precedential. And I don't know if an agency says we adopt the decision of the ALJ, is that not allowed to be precedential? Are we recommending that they can't make that precedential? I mean, I guess my recommendation would be just to take that whole clause out, but I'm not sure. There may be a meaning to it that I'm just not accessing.
Matt, Chris, Melissa.
Jack is focusing on what other than a summary disposition?
Right, that we're carving that out.
I mean, the only agency I can that comes to mind, I mean, Roxanne, I don't want to put you on the spot here, but NLRB is maybe a little bit of an outlier here and basically just adopting as its own ALJ decision, sometimes with a footnote commentary. That to me is not a summary disposition, but maybe I'm missing something here.
I mean, when the Supreme Court would affirm cases when it had appellate jurisdiction, mandatory appellate jurisdiction, those were treated as precedential, even though they didn't issue an opinion in most of them.
I think they're two different things. I think Matt's talking about something where the agency just makes a summary disposition on some matter, not when they affirm for the reasons that the ALJ said.
Yeah, yeah, exactly, Jeff. I'm thinking of a case in which, you have an initial decision, it's not, or whatever it's called, it's not, nobody files an appeal in the agency, it's just affirmed under the agency rules or statute. And that's not going to be, there's no agency at which I'm aware that that's going to be precedential. I am thinking I think you are of the sort of NLRB situation. Where the agency has specifically adopted the reasoning of the ALJ's decision.
I guess my question is, are we making a recommendation that agency summary dispositions may not be given precedential effect? And if so, is there language in the preamble or in the report that explains that in a way that someone can understand what that's about? Because in other words, are they going to think it's about the NLRB sort of thing, or are they going to think it's only about something else, which is an unappealed decision that by rule becomes the agency decision?
I don't think we have anything on it in the preamble that I'm remembering. Jeremy or Matt, Matt clues?
I mean, one option, would just be include these in the list below. We have A and B, and at a certain point, you would say that the agency should consider whether it issues, I don't know, decisions in which it doesn't provide reasoning for its decision, and maybe those are not useful as precedent. So I think that's one option.
Bill, solution, comment?
I'm with Jack. I think you just drop it. I mean, I don't see why you need it at all. I mean, agencies aren't going to make those precedential. We're not suggesting they have to. Should consider when or whether an appellate decision. If it's a summary decision, it's up to them what they do.
We need as precedential, not deleted.
That's what I was going to say.
Yeah.
I think Bill's exactly right and Jack's exactly right here. The phrase would require too much qualification.
Explanation. Okay. Moving on.
So I had a suggestion on this, which I don't feel strongly about, but it seemed like A is positive reason for doing it, and B and C were sort of reasons not to do it. So I suggested just combining, I mean, B and C were reasons not to do it. So I suggested combining B and C and putting in sort of a or conversely or something like that between A and the new B.
I thought C was a positive, that there's so many that it's difficult to sort through.
But it-
So
Well, that goes to my comment. Isn't that exactly the situation in which you want the agency somehow or other to flag those? I read C to say there may be precedential decisions out there, but there's so many decisions in total that we're just going to ignore them. And that seemed to me to be a somewhat defeatist approach. Maybe I'm reading it wrong.
Well, maybe I did misread C based on what Nadine said.
oh, maybe we need to rethink the wording. Hi, do you have a thought on this?
Yeah, I definitely thought that C was the reason to have some things designated, so it was a positive reason. But it also has a piece, that because they have so many, that's why we're also suggesting procedures like an adjudicator can bring to the attention, the individual adjudicator could bring to the attention, hey, you really might want to consider this. So I think it works the way it is. So I don't think we need a conversely. I think people understand that if you just scroll up a bit so we see that, in determining when agencies should consider, and I think often considerations are pro, con, and I mean, I think B and C have a lot to do with each other. You often have a lot of decisions when they are so case specific. But again, in terms of people understanding it in the agency when they read it, I think they'll understand that these are both pros and cons, and I think it's good to have the three separate.
Well, A is certainly positive.
Yes.
And
B is negative, and C can go both ways. And that's fine, right? I mean, that's reality.
I guess I don't understand C then. I mean,
I don't either.
Oh, okay. Well, I can definitely tell you from EOC about C. So can you go down? Okay. So EOC will issue like 4,000 federal sector opinions a year. Okay. Most of those are just straightforward applications. Some of them, it's just the AJ that's decided it, but that's not public. Then sometimes, by the way, it's appellate. Sometimes it's just straight from the agency, but there are a lot of them. Right now, technically, every single one of those decisions are precedential. But
say that again.
But it doesn't happen that way because there are just too many. And some of them should not be precedential. So it's a sort of combination. It's adjudicators cannot reasonably be expected to identify what should be. And you know what? The agency doesn't want every single one of those to be, at least at the EOC, because we just delegate authority to this Office of Federal Operations. So I think in the recommendations, you want it to be clear enough of what you're trying to address, and then let each agency decide how this applies in their own agency. That's, again, implementation wise, I feel like we sometimes try to imagine every single possibility and then stick it in. And I don't think we need to do that.
well,
So long as we are,
excuse me, but maybe C then
Yeah,
should say something like adjudicators need guidance,
right,
to identify which decisions.
C says that the adjudicators cannot be
Guidance.
expected to identify which decisions may control future decisions, but shouldn't somebody be expected to
Yeah.
do that? As over in
and then may should be
recommendations 10 and
should.
11?
Yeah, but then may it should be should. It should such that it cannot need guidance to identify which decisions should appropriately control. And that's what, so for those agencies that haven't made that clear distinction, like EOC and maybe others, that's something they should consider. as to a reason why they should make that differentiation.
Lauren?
Just to get, sorry, I'm stuck on the sort of the size of the word guidance akin to the way policy is these days. It's loaded. I'm not clear who would give the guidance, and so it makes me a little uncomfortable to think about who might say to an adjudicator, hey, we want you to look at this specific issue and decide it in this way, which I know what this is not saying in its black and white, but I'm a little concerned about how the guidance would be provided and, you know, career or political will be providing and things of that nature. I don't have an immediate suggestion on how to alter it. I was fine with the language as it was, but wanted to share that concern.
James?
Hi, thank you. And I'm an alternate for Scott Bullock, who's the chief judge of the Patent Trial and Appeal Board. And he had a point that some of our decisions are trial decisions. They're not all appellate decisions.
Okay. Bill, on this?
Well, my memory of the report was that this was a negative. That was, this would be a reason not to establish something as precedent. And I can be, maybe the consultants can correct me if I'm wrong on that, but I think we've completely changed the meaning of what was originally intended by this. And that may be okay, but it just, that struck me that we are changing what was being said in the report.
Well, let's hear from Matt or Chris or Melissa. I think we're reading them two different ways. That's not a good sign. Or Jeremy or Matt. Either of the Matts, Jeremy, Melissa, or Chris.
I'll defer to the consultants in terms of which way this should go. Candidly, in reading this before this meeting, I had the same confusion. So I'll leave it to the consultants to determine.
Can I try again? C says that some decisions, quote, may appropriately control future decisions. But there's so many of them that that the adjudicators can't be expected to figure out what they are. But if they may appropriately control future decisions, shouldn't someone do that?
Well, the lead into all of this is that agencies are doing that, right? Isn't that what the lead in says agencies should consider? So there's language added to the lead in here that's in determining whether adjudicators should treat decisions as precedential. Agencies should consider. So I'm not quite sure who's supposed to be making these determinations.
I'm getting more confused about C as we talk. And I suspect
because A and B are, you know, focused on the agency, right? A and B don't mention an adjudicator.
Right.
So it's the agency that has to consider this. But C now mentions adjudicators, which I think the idea is that the agency is going to help the adjudicators figure out which ones might be more valuable.
Sense, but can we rephrase it then to say something like that? What you just said, Nadine, that kind of parts the curtain for me. Adjudicators cannot reasonably expect to identify which decisions that blah, 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 and thus the agency has a responsibility to do so.
The extent to which adjudicators, so you're flipping the, yeah. Is that the idea? And while we're going to try that, Chris, do you have some input here?
Yeah, I mean, I think this is one of the core findings of our recommendations of the report is that, especially in high volume adjudication systems, it's really important to be selective about which decisions you make presidential. That's got to be, that's what we're trying to say here. I don't know. I think this language was kind of wordsmith in the last one as well. But I mean, I think that's a key finding. I know Social Security and veterans don't do it, and that's fine. But well, we can debate whether that's fine or not. I'll leave that aside. But But for other ones that have high volume, I mean, they really should be making some really important judgment calls to help adjudicators know what's controlling, what should they read in order to know what to do in certain cases.
Yeah, I mean, I
go
agree
ahead,
with Chris.
Matt.
Oh,
Yeah.
I'm sorry. I
No,
agree
no,
with
please go.
I agree with Chris 100%. There's just going to be, if you have a high volume adjudication system and you don't draw these distinctions, I mean, you're going to have decisions in the system that you're going to have decisions out there that really effectively are not of much use to adjudicators. They might be highly fact specific, mixed questions of fact and law and so forth. But in any event, they're just you can't expect the adjudicators to pick out in a high volume system what they should be focusing on. That's the point here.
Hi, do you have some language?
Yeah. Yeah, so can you go back up? I don't know how I'm sorry if I missed this conversation. Okay, in determining whether by changing adjudicators should treat, that's not what I thought we're doing here, right?
I agree.
Look at the first sentences, right? Agency should consider whether and if so when to treat appellate decisions as precedential, meaning blah, blah. In determining whether, so this is in the agency determining whether, so I would just take out adjudication treat, you know, when the agency determines whether all, some, or no appellate decisions should be treated as precedential, agency should consider. I don't think you need to change anything. I think in determining whether clearly goes back to the first sentence of the agency should consider. In determining whether all, some, or no appellate decisions should be treated as precedential, here's what the agency should consider.
Okay.
Obviously, it's going to be then controlling on the jury.
Yep. I'm going to jump to Roxanne quickly. We can't hear you.
My suggestion is really small, which is in C, where it says such that. Should that be because? That's all I had.
Jack?
I just wonder whether C, I don't have language, but whether C should go back to the concept of guidance and that say that adjudicators need, guidance from, guidance is a loaded word, but whether adjudicators need indications from the agency, something about, so that it goes back to that it's the agency's responsibility to tell the adjudicators when to treat them as precedential.
I was thinking that was clear from the opening, which is that, the agencies are going to be doing this. This is the agency's responsibility to, all of this could be guidance, right? Jeremy?
I'll try. How about something like the extent to which designating some decisions as precedential would identify for adjudicators which among a high volume of decisions should control decision-making in future cases? So the extent to which, let's see. Yep.
Was that it?
Did he get it?
Yeah, that's it.
Okay. All right. I'm gonna call on Russell and Jeff to see if this is some, I like it, but
I do too.
clarity. Yep. Jeremy Goldstar. Lauren.
Sorry, I read this and think it just defines what a precedent is. I'm not sure. Like, it sounds like we're saying that the agencies would consider how much a precedent would control future decisions when there's a bunch of decisions.
How about would identify which specific decisions among a particularly high volume of decisions? Does that emphasize that volume issue more? Which specific decisions among a particularly high volume of decisions?
Take out particularly. That just confuses me.
Extent to which decisions. I still, I'm still, and if it's me, then I'll withdraw, but it seems to me that we're saying that there's potential that some of our precedent wouldn't control future decision-making. Like the focus on the high volume seems to be like you have too many cases to worry about that the precedent would necessarily apply to all of them, even if it's applicable.
I take it the point is that if you have thousands of decisions, it's difficult for adjudicators to consume all of that information. So to the point that you want cases treated similarly, it's useful to point out, okay, these are the 10 to 15 decisions a year you should pay attention to. Don't worry about reading and consuming all thousands of them.
Which kind of takes us back to the language we had to start with, which is leading with the concept of a high volume, right? So it mirrors what A and B say, which is to the extent to which the agency issues a high volume of decisions and adjudicators can't discern which ones are. I mean, we're kind of right back to where we were. High, help.
Yeah, I was going to say, can we just see what, if we go back to where we were, whether, like, sort of what the problem would be with that? Because I do think we have finally gotten, so just take that out. So a third thing is, as they're figuring out whether to do this, the extent to which the agency issues such a large volume of decisions that adjudicators cannot reasonably be expected to identify which decisions should, that's why we take out may, which isn't taken out there, should control future decisions. Like I said, for those right now, where they don't make that differentiation, adjudicators can just decide on their own which is precedent, and you may not want that. You know? And let me tell you, they don't read every other decision, but sometimes if a person cites that decision, and then they go and then they think, oh yeah, that's precedent. We don't necessarily want them to do that, which is why we're going to have a process for what to do when they do cite those. So I guess I'm not sure why we need to change C, but I might have missed that.
Any further? We're right back where we started, but we've hopefully got a little more clarity. I don't know. All right, I'm going to take silence as a good sign. Let's move to 2. We had commas in D from Jeff, federal for consistency. Jack.
I had a comment that the first instance of it is the first sentence of 2, but it repeats a few other times, which is, I don't like the words choose to in that sentence. Agencies that choose to treat, I just would say agencies that treat.
I had that exact
choose
edit.
to just seems surplus, and it's repeated a couple other times, and I would just take it out everywhere that it appears. I mean, unless there's some special reason.
No, I agree. Any other comments on 2 and the list? Great, let's go to 3. Oh, Jack, okay, I'm assuming that was still up from before. Okay. 3. I think, is this Jeff adding generally? And maybe Russell. I don't know who added other. Was that Russell or Jeff?
Yeah.
Russell. Okay. Any thoughts on that? Kent.
I'm just curious why we would want agencies to prohibit the parties from citing non-precedential decisions in some cases.
So would you suggest that your concern is the but or the generally?
The generally.
Okay. Jeff, any
Isn't
response?
that the case now? I mean, currently some agencies do that?
I know there are some states that do that, but I've never heard it complemented as a practice.
Yeah, I don't think that, I mean, this obviously is a debate that was all the rage in the federal court several decades ago, which resulted in an amendment to the federal rules of appellate procedure. I don't know if Chris or Melissa recall, I don't recall any agency rules that prohibit, apropos of Ken's point, prohibit citation. There are rules that say the agency doesn't have to address it, extinguish it, and so forth. But I don't know that there are any rules of prohibition. So if the ACUS wanted to follow the rule practice of the federal courts, you would not want to acknowledge prohibition as a sort of a legitimate practice.
Jack, did you have a response on this?
I had another small comment on the same sentence.
Okay,
Well,
David?
if there are never any situations where they do it now or they should do it, I withdraw generally.
David, did your point go to that or no? Okay.
No,
Jack.
it's different, actually.
Okay, all right. Then we'll start with you since you're unmuted, and then we'll go to Jack. Go ahead.
So I'm confused. On a quick read, I was really confused by paragraph 3, and just let me see if others had the same problem. There's kind of a weird greater, lesser included thing going on here. So it opens with a strong statement that you shouldn't prohibit, but should also specify, circumstances when you could cite it. And if out of the choice set of 8 reasons they could cite a non-precedential decision, the answer is 0, well, that's the same as prohibiting it. And so I guess I really stumbled over it the couple times I read it. So if others had that same confusion, or now that I've noted the confusion, if others see it, I'm not sure exactly what the fix is, but yeah, again, I think the best way to conceptualize it is there's kind of a general lesser included issue here.
Jack, is it on this? No?
Yeah, I mean, I think it is. It struck me as a little bit odd, but I assume there was something behind this that if we're saying they shouldn't prohibit citing, but they can decide how they will consider it. Would that include saying we're not going to consider it? But
yeah,
I'm
with you, Jack. I thought maybe I was just a country lawyer and there was something really subtle going on that I didn't understand.
But I think maybe there's something. I thought maybe there was something behind this that because I hadn't read the report carefully. But the other thing is, I didn't understand the addition of the word "other." I don't see how "other" adds anything to this, and maybe Russell will tell us. But I didn't understand how the word "other" adds.
Well, I read it to say that you can't use it in written or oral arguments, but there may be other circumstances in which somehow or other you could do so. I mean, that's the only way. That's why I read it. I was confused by the same thing too, but otherwise it seemed to say you can't do it, but yeah, you can't. Sometimes you can do it.
But it says for what other purpose the party may cite. I mean, it's not saying that may not. So I don't understand what the word "other" means in that context, I guess, even after your comment just now.
Ken?
The way I have always understood this debate to play out is whether or not one can cite the non-precedential decision as persuasive authority. So I wonder if just adding after oral arguments as persuasive authority, period, takes care of the main debate that's always surrounded this issue.
And Chris, did you have a comment on this?
Yeah, I mean, this is the thing that agencies have struggled with is they don't prohibit parties from citing it, but they don't necessarily make it really clear that when you do cite it, it doesn't bind the agency, that it's just persuasive. It's just, and some agencies, they don't even want their adjudicators to view it as persuasive, like they want them to base it just on the presidential decisions and not be worried about interdecisional inconsistencies in other cases. So I think it is worth kind of saying you shouldn't prohibit them from citing because that's the federal court standard that should be there, but then say something after that, that it could, but they should say and remind the parties that it's not binding, it's just persuasive or something along those lines.
I think Kent's I'm sorry.
Oh, no, go ahead, Russell.
No, I think Kent's addition solves a lot of problems.
Bill?
Makes a lot clearer to me.
Well, I'm not clear now, which is which is they can't prohibit them from citing it as persuasive authority, but they can, what can they use it for? I mean, what I'm thinking of is the poor ALJ who gets a bunch of things cited to him, and he has to waste his time looking at them because he didn't, one, if he doesn't know that what they're being used for. And why are they there if they're not persuasive authority? I mean, I don't know. I'm just left with not be cited. Shouldn't prohibit them from citing it as persuasive authority.
Well, one thought is that you make it clear, I think the agency the commission that I work for, the agency makes clear that when you can cite it, but if you cite it, you need to indicate that it's an ALJ decision, and therefore that would indicate that it's non-binding. So to the extent that it indicate, that you shouldn't prohibit from citing as long as, provided that it's apparent from the citation that it's not binding.
We have somewhere else in the recommendations here, and I looked for it and I couldn't quickly find it, about if you cite non-precedential decisions, what has to be done. And maybe that would cure my concern, but it's, can the agency prohibit parties from citing non-precedential decisions, period? I mean, it seems like we're not telling them that they can't just say, you are prohibited from citing unprecedented decisions. Because we've only told them they shouldn't do it for persuasive authority.
Roxanne?
Yeah, I think this conversation highlights why this whole recommendation is important, because earlier we had said that the agency should designate what decisions are considered precedential. That helps guide people in their arguments. I don't think that agencies should prohibit parties from arguing anything. They can argue whatever they want as long as it's not inappropriate. For the NLRB, we have published decisions; those are precedential. We have unpublished decisions, which are not precedential. And on our webpage where we post our unpublished decisions, it says at the top, the board decisions listed below are not binding precedent except for with respect to the parties in this case, or in the specific case. And so to that extent, we have people cite unpublished decisions at times because the facts are right on point. And sure, then that's persuasive. But I don't think it's a problem for the adjudicator, the ALJ or whomever, because they know it's not a published decision, so they're not bound by it, but it might be persuasive. So that's all, just to say that to the extent that the agencies take the recommendations here and clearly identify what are precedential decisions and what are not, then I don't think there's going to be a lot of confusion by the adjudicators.
Pat?
Oh. Well, I took it down because my point was largely Roxanne's. I don't think this tends to confuse that much where it's used in the lower federal courts, and they're used for the same purposes that she was saying. If we've already said up above, here's how you designate, and this needs to happen, we're left with this class that aren't designated and whether or not they can be used. And I think they should be able to be used for the reasons she said.
I'm hearing music. Matt.
I think one other reason that's highlighted in the report, mentioned in the report, why they should be cited is that it's possible that a party might want to tell an agency, and especially the agency head, that there's a line of non-precedential decisions that the agency is deciding cases in an inconsistent manner. And there are judicial decisions that say can't hide behind precedential decisions. You can't just say, well, we're not following, we're deciding cases inconsistently because some of our cases are non-precedential. And so I think parties should have the opportunity to point out to the agency potential inconsistencies that reside in their decisions. And that might include, in some cases, identifying non-precedential decisions.
Okay. Do we have any other comments about leaving it as it appears on the screen? Bill?
I found the other place.
Oh, good.
And and it reminds me of what we did at the last meeting. First of all, I have no problem with the agency should not prohibit parties from citing non-presidential decision, written or oral arguments, period. I think that's fine. But we had taken from a later place in the recommendation and put here the question of the agency explaining when and for what purposes a party may cite an unprecedented decision and how the agency will consider it. And that is actually, it was supposed to be deleted from the later place and put here, but we've put it here, the staff have put it here, but it's also in 16F. Is the exact same language, except it's not determine when, but explain when. So I mean, my original thing was to try to put all this non-precedential decision stuff in one place and therefore have it all in 3. But, you know, we could argue about this, the second sentence when we get to 16F, or we could argue about it now.
Any thoughts about whether the concept from F should stay at all in the recommendations? And if so, where? Is it better here or in the list? I know we're not at 16 yet. That section is titled Rules on Precedential Decision Making. So the idea is that the rule would explain. I actually kind of like it now that I'm reading it, like it there, maybe keeping it there, but hi.
Actually, I was gonna recommend just putting that period, you know, not prohibiting it. And then when we get to what the agency should be telling the public, let's talk about whether it makes sense to suggest that they make that clear to the public, because what Roxanne said about the NLRB made a lot of sense to me. So I think here, this is about the agency deciding whether to make things precedential. And our only thing on 3 is, and by the way, even if you now do this and you haven't done it before, like NLRB, don't prohibit them from citing. And then I think the adjudicators will understand what that means. And then below, we can decide whether we want to keep this in as an F. I mean, that's my gut right now.
Okay. Any other thoughts? We'll deal with it later. Thank you for locating that, Bill. That's very helpful. Thank you. All right, let's move on to 4.
Actually, you can see Jack's question whether to take a break now.
Oh, I did
which
not see it. Thank you for.
Jack just put it in.
Yeah, you know what? This is actually a good spot to take a break, and I'm not going to turn Jack down on that. Let's 5 minutes, 10 minutes at the. Let's try for 5. Can we try for 5? Because we're running low on time now, and we've got a lot of paper to go through. 5 minutes. Thank you. Okay, we are on 4. Well, actually, we have a shift in the title here of the heading, and then 4. Any comments?
Staff added 4 at the request of members from the previous meeting who wanted to incorporate some of the additional recommendations from the report.
Great. Okay, let's move on to 5 then.
Wait, did you skip 4?
We did, well, yes, no. What do you got on 4?
I didn't get this one at all.
Okay.
To be honest. First of all, the word streamline kind of hit me wrong. So I was looking at this. First of all, the first sentence I get, but then the second sentence, but I would just read it. I would redo it as agency procedures for designating decisions as precedential should not be unduly time consuming or resource intensive. Because I didn't like the word streamline.
Can you repeat?
Okay, agency procedures for designated decisions as precedential should not be unduly time consuming or resource intensive.
So you would get rid of such on 92, such that they are,
Yeah, it just should not
and they
be,
say should not.
be unduly time consuming or resource intensive.
Mhm.
And then the second sentence seemed like another sort of like a half-baked precedential designation system, which is totally like comes out of the blue to me. Like the idea is that there might be decisions that aren't precedential, but might be adopted or informative or
It's in the
something else.
report. It's in the report, Jack.
Okay, but then does it belong here? So you know, to avoid unduly time consuming or research intensive procedures, agency may also consider then, I guess. I mean, because again, streamlining, I just didn't like streamlining. So when it would be, you know, agency, yeah, okay.
Mm-hmm.
Okay, then that's fine. But I just didn't like streamlining.
Well, it's out. Successfully out, Jack.
I think I have a comment here though now that I look at it, adopted and informative seem two different levels of intermediacy here. I mean, adopted sounds more like precedential. Informative means, you know, take a look at it. You could say highlighted, or you could say, you know, I don't know, it's a guiding case or something, but I mean, so I know this is derived from the report, but if we're going to put in the recommendation, maybe we ought to think about it a little bit more.
Roxanne?
I was going to ask if we really need that first section of that second sentence. Do we need to say to avoid unduly time consuming, or can we just start that sentence with agencies? Because then you're just saying, okay, mark them as precedential. And you might also want to consider marking some that aren't precedential in the following ways. And if we do that, then, you know, to Jeff's point, then, okay, maybe some are adopted, maybe some are informative. That may mean different things, but that's okay. We have a section where we call certain board decisions notable because we didn't want to like indicate whether we thought they were positive or negative. They are of note or notable. You know,
let's put that in. Let's put that in.
Yeah.
Notable.
But we're just throwing out ideas here, I think, for agencies to consider.
Bill? Oh, yeah, Bill.
I didn't see why we should argue about what between adopted or informative. I mean, or similar term. The real point is that if they decide to use a term, that they ought to tell people what the hell they mean. Right? And we don't have that here, but that's okay if we remember to put it in the part of the recommendation dealing with what the public gets to know.
Yeah.
So that's my point.
Okay, Chris, did you have a comment about what this?
Yeah, I mean, I would just note, so adopted and informative are what certain agencies call them, right? So that's why they're in quotes and they're there. If you can add notable, I mean, so adopted is what USCIS uses, informative is what the Patent Trial and Appeal Board use.
I wondered if the hearing level or appellate level needed to be there, or should we just say to adjudicators? I'm not sure that we've used that language throughout consistently. Okay. Anything further? Chris, you still have your hand up, but is it from before? Yeah, okay, fine, got it. 5. And let's see, Jeff has a comment about 5 and 7.
Yeah. So 7 talks about designating existing appellate decisions as precedential. 5 is about presumably a case that's still being decided.
Yeah. Still in the oven.
Yeah.
There is overlap because they both start exactly the same way.
Right. Maybe we could combine them or put them one after the other.
Somehow put them together. Yeah. Matt, could we let's move 7 up under, flip 7, 6 and 7 maybe, and then we can look at it a little closer.
And why should the public be mentioned in 7 and not in 5?
So we've got them together now. They're 5 and 6. Jack.
I think we talked about this last time, that the reason the public wouldn't be involved is because it's during the process of decision making. But I also think that it would be better to leave it singular, because you're talking about like each individual case in 5, whereas in 7 you're talking about maybe a number of cases. But that's Jeff. That's why I think my memory is why 5 and 7 were different in that way.
Right. Okay.
Thank you. Hi.
Yeah, also referring to conversation at the last meeting, I don't think 6 and 7 should be flipped, because 5 and 7 now are both, like you were saying, cases that are ongoing, right, as opposed to existing. So I do think there are two things that are important when they're ongoing. We sort of reference. One is, okay, it's come from, you know, an AJ decision, come up to your appellate. We're thinking we're going to make this precedential. You know what? Maybe we want to pull in a few other adjudicators not involved in that case that we want to talk to, right? I almost feel like 5 is the agency deciding they want that, while what is currently 7, and I think should go back to 6, is, you know, that the adjudicator refers it up. Like, hey, before I...
Interlocutory, yeah.
It's the interlocutory piece, you know, which I do think it's going to be very helpful in some situations.
Would it help to move the final clauses up to the start? I mean, so that, I mean, to the extent that there might be confusion about what stage we're talking about. So in 7, for instance, you could start off by saying, you know, and considering whether to designate existing, and then do the same for the others. But I'm not quite sure, you know, maybe there's a little bit of confusion here about at what state, you know, what different stages we're talking about. I'm not sure how to bring clarity to that.
I think that's a really good suggestion, to put the whether to designate and prior to designating to start the sentences.
Okay. So let's try that in 5. Okay. And then do we need to do the same for 6, since those are both, no?
No, because that is interlocutory appeal, right?
Okay.
That's just procedures for it.
We'll go to Matt first. Consultant.
I just have one suggestion on the language about interlocutory appeals. I would just recommend that maybe after the meeting, if there's going to be another draft, that we and/or the staff, the consultants and/or the staff, take a look at the agency appellate systems and also the model adjudication rules. The language there about, I'm struggling to read it a little bit on the screen, about referrals and requests. I'm not sure it entirely comports with prior ACUS work in terms of how we describe how an interlocutory appeal may arise.
Okay. Jeremy?
On what is now 7, and I will pose this more as a question for the consultants. My recollection in putting this into words is that this refers to processes. I think PTAB has it. I believe the Medicare Appeals Council has it. Where basically there's a suggestion box on their website where people can nominate existing decisions that are not designated as precedential to be designated as precedential. So it's not necessarily in considering whether to designate a specific decision as precedential, but basically accepting or soliciting input from the outside on which decisions might be precedential.
Thank you.
So does that require a change? Because it seems like we're saying it implies that it's designating an existing appellate decision rather than an overall process, like.
I think, were you talking about 7, Jeremy?
7, yeah. Right now, I mean, it seems, to me at least, it seems a little ambiguous in terms of am I considering whether to make a specific decision precedential, or am I just soliciting input from the public on, are there decisions that you think should be precedential? Let us know. So it's more of a general suggestion box for precedent, as opposed to we're soliciting input on whether, case number 153 should be precedential or not.
It could be both. Somebody could suggest one, and then the agency might want to solicit opinions about it.
I think the language we have now covers both those situations.
Matt? No. Hi.
I think I think this is one where we don't want to put in considering upfront, because was it Jeremy just made that point? I think here it is, agencies, I mean, you can even also should have procedures, but we don't need it. Agencies should consider soliciting input on whether to have existing appellate decisions as precedential. I mean, that's, I think, what we're not really telling them. You do need to go back and look at your existing appellate decisions. You're probably going to want to, but one good way to start is ask other people, which ones. And I think that's going to be more clear. So I liked it for the other two, changing it, but I don't think it works as well here.
Okay. Anything further on these 3? The interlocutory appeal piece, we had a comment from, was Wendy SSA or EPA? EPA. Jeremy, do you have
I believe that's what Matt was referring to or responding to earlier, that we'll go back and look at prior resources and see how the term is used to make it consistent.
Make it clear. Okay, Bill?
I just thought instead of implementing, it should be adopting. Because we're really, implementing sounds like they already have the procedures and they should use them.
Yeah. Anything further here? Okay, 8.
Wendy also had a comment on 7.
Oh, sorry.
I have it on the screen now.
Well, that was the one, we're talking about existing, right? Not. There's going to be a process before a decision is issued that's presumably in place, but then, yeah, I guess I'm not clear about the comment, but is she asking about the timing?
I think this goes to my original comment, which was that 5 and 7 seem to be overlapping, but I think her comment goes more to 5 now. Because.
But it's clear in 5 that you're not seeking.
I know. So I don't think.
And I don't think she's not asking for it.
No. I think she should be happy because we're not talking about asking the public on pending cases, only on existing cases.
Jeremy?
I think the confusion is whether you should solicit input on whether you should have a process by which decisions can be designated, or B, whether you should take basically input as to which decisions. So what if you said something like, should consider soliciting input on whether any existing appellate decision should be designated as precedential. Or like non-precedential decision should be designated. I don't know if that matters, but something more along those lines. Or accepting nominations for designating non-presidential decisions as precedential, something that makes it clear that you're not talking about a process, a general process, but a process with respect to specific decisions.
I hope you'll move from adjudicators, et cetera, up
Yeah.
after input.
Yeah. Well, accepting, it says accepting now, accepting nominations from.
Okay.
There we go. I think that might drill down a little closer to what the intent was here based on what Jeremy had said earlier in terms of, you know, like a box, a mailbox, an inbox, a suggestion box. Any reactions to that? All right, let's move to 8. We got nothing but an and. I like that. Nine, we had a style edit, a good one from Jeff. All right, let's get to availability. 10.
I'm
Yeah.
sorry.
Yeah,
This
go
is a
ahead. This
choose
is
to.
Jack. Yeah,
Yeah,
Jack.
I'm sorry.
Good.
Choose
Yes.
to attend.
Yep. Thank you. Thank you. Thank you. I missed that one. I had the first one, but I missed that one. Okay, anything? 10, 11, 12, 13, well, 12 through 15. These are all pretty straightforward. Okay. 16. This is about the rules. This is where we're going to deal with some of the specifics. Adam.
Maybe this is pedantic, but at line 40, reference adjudicative agencies. And I noticed that's the only time that we qualify agencies with adjudicative. I think that's probably right, but that probably applies to all of the recommendations.
Yeah, and now that you're saying that, there's the spot I think earlier where we say adjudicating agencies.
Maybe we do.
Yeah, I think we had that earlier somewhere. We can flag it, committee on style, right? But I don't think we need it. That's a good catch. I mean, unless we want to use it elsewhere.
I mean, I thought maybe like you could strike it there, but put it in the preamble where there's a place in the preamble where we kind of say like what this report or what the recommendation broadly does. I'm trying to pull it up. Where it says the recommendation identifies best practices for agencies considering whether and how to use presidential decisions in their adjudicative systems. Like maybe that's a place although it's kind of, I guess it's kind of implied by the end of that sentence, but yeah.
Okay.
Nadine, can we go back one to 15 for a second? Just rather than are remanded, have been?
Yes. Much better. Thank you, Jeff. Okay. The list of what we think the rules should include. I know we had Let's do A and B, and then we've got anything on A and B? Jack? Nope. Okay. Adam? Nope. All right. Let's go down to the the red line now. C. D. Oh, hi. Yeah.
Just a quick thing. Who is it that once that the adjudicator decides that it's precedential? I just, I mean, again, this is just a recommendation, but that just seems like, I don't know, lots of adjudicators could start saying, yeah, you know, half of my cases are real. I'm just not sure where that's coming from.
So we
I
need
think
the, for example, maybe we don't.
exactly. I don't think we
Yeah.
need the, for example.
Okay, thank you. D. E. That's a correction right there. Thank you, Jeff.
Also,
had
we
informative
put in-
earlier.
we put in notable, and also there's a lack of parallelism in terms of the way this one begins, because all the other ones start off with a verb.
With a verb.
This one and
Identify.
some of the other ones down below also start off with if. So we just have to conform those.
Yeah. Can we delegate that aspect to committee on style, maybe? And let's see where this goes with David.
I think you either, well, we may be changing the whole thing, but you know, starting out with identify, but if not, you either need a comma after term or you need to remove the comma after what is now informative.
Bill?
This does not identify what those terms mean. And that was the point that I made earlier, which is that, you know, if they use these terms, that it's not precedent, well, what the hell is it? What does it mean to say notable? And I think therefore we need something here, not only to who decides, on what basis they decide, but also what effect that designation has.
It identifies useful decisions.
Beg your pardon?
It identifies useful decisions.
Useful. In what way? Useful in what way?
That's what it says.
In a non-precedential way.
Useful in a non-precedential way. Okay. I mean, I don't know. I mean, if you want to say it can be used for as persuasive authority, that, you know, for example. But I mean, I just say identify, you know, the meaning of the term, or how what they mean.
What they mean by those terms.
How these terms can be used.
Well, maybe how's notable? What does notable connote at the board?
I don't know if we still have Roxanne.
Oh, I'm here.
Yeah.
Well, what we do is actually we use notable within our precedential decision. So we have a lot of published decisions each year, but we want to designate for the public which ones are precedent setting or considering issues of first impression. And so we have a separate listing on our public website of notable board decisions, and we define it right there on the page, at the top of the page. We say these are board decisions that may be of special interest to the labor management community, and then we list the decisions with a brief summary, and they can link and read the whole decision if they want to. But it's our way to try to keep our constituents informed of what are the big decisions that have come out that they may want to take a look at.
Well, that's a wholly different. I mean, that's for your precedential decisions, right? And here we're talking about non-precedential decisions.
Yeah, I was just throwing it out there as a term that might be used. It's one that we use, but not in this context per se.
But I understand that if it's precedential, we know what effect it has. My point is, if it's not precedential, but it's notable.
Something else,
Or
right?
informative or adopted. Well, what the hell does that mean? So that's identify the meaning of the term or
Define the term. Melissa, please.
So I was just going to weigh in because PTAB uses the term informative, and they define it as it provides board norms on recurring issues, guidance on issues of first impression to the board, guidance on board rules and practices, and guidance on issues that may develop through analysis of recurring issues. They specifically say they should be followed in most cases, absent justification, but they're not binding on the board.
Wow.
So that's PTAB's version of informative.
Yeah. Wow. Okay. Jack?
I just had something about three different things in this little area, but on the issue of these different terms, I could imagine lots of situations in which a decision is notable, but it doesn't establish new precedent. It could be like an important decision on a matter where there's already precedent and they've applied the precedent to a novel situation. You could have a situation where you're talking about procedural practices where it might not be obvious from the rules how to do something. And so this gives you an idea of a way to do something. And so I could see something being notable in the sense of here's a suggestion where if this issue or this problem comes up in your future cases, you can use this methodology to deal with it without it having the same status as like a precedential rule. So that doesn't really bother me very much. I mean, I think it may be, saying it, not presenting it as an either or, but as a different kind of designation. But I do agree that we need to it needs to be defined in some sense.
Yeah.
And I also, so that's. But then I'm in agreement with we should take out all of these. Explain the if the agency considers, if the agency every time that appears, we should just get rid of that and start with the verb, which like in G and H is describe.
Yeah.
And that they should always start with a verb. All of these should.
Yeah, and C it's specify, right? I mean it's describe, state, specify. Yeah. Hi, do you have language for?
I was back down to the informative notable.
Yeah.
And because I was going to say that I thought that Roxanne, what you said was very helpful, that NLRB does have certain ones that they just highlight for folks. Hey, whatever term you use, I think you would maybe the notable. So I think so I just want to say, I think that's very helpful. I hate the idea of asking about something in the preamble, but this is a really useful point. And do we have anything in the preamble that says, here's all the reasons why you might consider, the precedential, but what some agencies have done beside that is also identify these, because I think some agencies might be concerned that if they have precedential, then like everything else is, chop liver or whatever, doesn't really mean much, and they have some stuff that's useful. So I didn't know the NLRB does that, and I think it's a good idea. So, okay.
We could build that into the.
Go back a little. You were before, because this was in deciding whether you want to. Isn't that no? Go up one more. Okay. Many use some forms, some treat all, others treat some.
There's that other than summary orders we have in there. Never mind. Sorry, just flagging that.
Let's take that out. Treat all appellate decisions as presidential. Others treat only some, and maybe it's the sentence after
others. Yeah, others treat non-precedential decisions as, or others highlight
non-precedential
decisions by labeling them, notable, informative,
notable or informative, albeit
whatever the list is. Yeah.
And actually, why don't we say a notable? Others highlight certain decisions or certain decisions it's because I want to say informative and notable, comma, but not precedential, and to convey the point that you're doing that because they're useful in other ways. So it's, highlight certain, I want to say useful decisions, but I just know that's going to be, let's just put in useful in front of decisions, and then we can decide if we just useful. I know people will say, what does useful mean? But, and then it's not a new sentence, so notable, comma, but not precedential.
I don't think we need
some
certain
of-
and useful.
Some of them are precedential. I think, didn't
No.
Roxanne-
That's, and I'm not sure this sentence goes here, 33 to 35. It's really, so let's, because I think it might be after this paragraph, okay? You know what? It does go after this. Don't delete it yet, but let's see in terms of where we're going to put it. All of this is precedential. Go back 41, best practices on how to use it, begins by recommending to lend themselves, whether to treat all or some criteria, keep going down. I think it's probably at the end of all of this, because all of this,
Well, the 41 down just starts identifying all of the recommendations.
practices.
So
Okay,
to the
let's
extent, I
see
think
where
that's
this
the
goes.
paragraph for it, but we could,
Right, and
we could leave this for the committee on style to kind of
that's
figure
what
out
I
where it
think.
fits.
Exactly, because you want to let folks know that's also an
And
option.
then that gives context for what we say in the recommendation.
Exactly.
But I think it would be better to say others highlight certain, useful
Certain-
non-precedential decisions by labeling them.
Okay, that's fine. Useful non-pre by labeling them adapt, informative, and notable, and then it's clear that they're not precedential.
Yeah.
Okay. But again, committee and style should figure out like sort of where that best fits so it doesn't undercut the flow.
So if we go back to that part of the recommendation. I think the idea here is to define any any terms the agency uses to identify useful non-precedential decisions.
I would say highlight useful non-precedential.
Uses to highlight, and define any terms that the agency uses to highlight,
Yeah, in the next line.
not employs, uses to highlight
No.
non-precedential useful decisions.
Mhm.
No?
Yeah.
The criterion, but I mean, so now we kind of got this last part, the criterion process for designating those decisions.
Right.
Period.
I would, why highlight rather than identify?
We used highlight earlier, that's just consistent, but identify. Let's try it. We don't need the even if not formally designated phrase.
Exactly. Just an and.
And
describe
we just need an
criteria.
and.
Mhm.
Yep.
Yeah.
Great.
Yeah.
I think that's good. F is the point that we discussed earlier about we're not prohibiting the parties from doing it, but we want them to explain, we want the agency to explain for what purposes. This is assuming that they can do it. And we just want you to explain when and how. So I think that works here.
Yep.
Anything on G? G, H, and I.
I didn't think H was necessary. I mean, or what kind of criteria are agencies going to publish talking about how they might overrule or modify a precedential decision? I don't think anything useful would come out of that, really. I mean, I may be
So you
wrong.
would strike it.
Yeah, I mean, I'm willing to hear arguments. against
Hi.
it.
No, I don't think we need that. That's just, you know,
Yeah.
we should know the criteria process. My comment was going to be on the previous one. Back
Okay,
to the.
well, let's delete
Q2.
H.
Oh, yeah.
Let's get
delete
that
H.
deleted unless,
Sure.
yeah.
All right, it's just because it was the one before. Back to the choose, I think we can just start with describe any opportunities.
Yeah,
or the
I think a
public-
lot of these, we can have the committee on style kind
Yeah,
of.
okay, good, okay.
We have a couple other ifs, I think.
We have a couple of
need to-
others, right?
Yes,
Okay,
yeah.
good.
Yep, perfect, yep. Great. I think that's it for the list there. 17 and 18. Anything else here? Jack?
Yeah, I just thought in 18, there was no reason to have voluntarily in there. Agencies should use notice and comment procedures.
I think the idea there is that there are some well, I guess I mean, there are some situations where you don't have to use it, right? So
Right.
we want to encourage, I think, Jeff, we talked about this last time.
Yeah, but it's got the notwithstanding in there, so I don't know if you really need volunteer.
Yeah.
Yeah.
That's why I thought it was redundant.
Yep. Thank you, Jack. Anything further here? Wait, is that the end? Are we at the end?
Yes.
Great, fantastic. Matt, anything else we need to, before I try to get a vote?
I
Jeremy
don't
or
believe
Matt?
so.
Anything outstanding that we need to cover? Got it. Could we finish early? Is that possible? That would be fantastic. Scroll through the comments. I think we caught them all. Great. All right, I got to pull up I'm not ready. I thought we had more to do. Oh, Bill, I spoke too soon.
Well, Matt Weiner had raised the question about the interlocutory and I didn't know if that was just going to be a style thing or whether that was going to be substantive. So
That might, yeah.
that's
Hi. Did you have something?
No, just before people just run off after the vote, per my discussion with you, I do want to just raise an implementation point.
Yes,
after the
thank you.
vote.
Please, let's put a
Totally
pin
after
in
the
that.
vote.
Please don't let me end things without that. Okay.
That's all.
Okay. So the interlocutory, this was 6.
Jeremy was going to go back and look at the recommendation on appellate.
Yeah, I took that as stylistic because I think you all agree in principle as to what that means, and we're just going to make sure that we use the same term that we've used in previous recommendations.
And also, Jeremy, I was thinking also more also about the model adjudication rules, which Kent Barnett drafted. Though I had the appellate section, so I don't expect him to remember, but maybe we ought to take a look at the Mars too.
Jeremy, do you think that's something, should we do? I know sometimes we circulate another draft for an email vote as opposed to reconvening.
As long as it's just a terminology thing and everybody agrees in principle as to what it means, I think it's fine to go ahead and vote now.
You can always comment at the plenary session stage.
Correct.
Absolutely. Thank you, Jeff. All right, well, let us vote. Let's do hands. Can we all do hands? Show your hands. Let's see if I can figure out how to do that. All right.
Did you call the vote?
Yes, please vote with your hand.
Okay.
That's what I
I'm gonna
meant.
vote with the raised hand. I had done it with a thumbs up, but
That works too. I'll take a thumbs up. Anybody else that I'm not seeing? Matt, is that? We have everybody.
I think the
Okay.
ayes have it.
Yes, I would say so. Thank you. Great. Thank you, everybody. All right, well, I'll just say, and then I'll turn it over to Andy for some closing comments, but I just want to thank everybody. I learned so much from these meetings, from all of you, and always really incredibly constructive input. And this work is nothing without your contributions. So I thank you for your time on a beautiful fall Friday afternoon. Andy.
Yeah, thanks. I just want to say that I think this work today that you all have done together is a reflection of at least 3 of ACUS's core values that we live by. The first is consensus-driven decision-making. And for that, we have so much to thank Nadine for. I think it's just amazing that 25 lawyers can agree on a text like this, and do it consistently and congenially. Second is volunteerism. You know, you're all volunteering your time for improving how the government works, and we everyone at ACUS appreciates that. And the third is expertise. You know, you have your expertise, you volunteer it, and you create great products for us. So I just want to say, on behalf of everyone at ACUS, thanks to everyone. I look forward to shepherding this through the council with you and the full assembly. So thanks a lot and have a good weekend.
Thank you. Before you sign off, I realized I promised Hy to say a few words. So now that we've got the vote done and we've got our closing remarks, I'll let Hy have some final words.
right. Well, actually, my closing remarks fit perfectly, Andrew, after what you said, which is just talking about our task force on implementation, how to make sure that all of this hard work, Andrew, that you said, is gets to the people in the agencies that this will be helpful for. And I noted, by the way, that Colton Haddon from EOC has been able to be listening to this. He was one of the folks in in the Office of Federal Operations was the interviewee. And so my recommendation in terms of helping with implementation is that we know that, as Chris and others said, you will be going back to the folks who interviewed in terms of the report, make sure you got stuff right. I would also recommend just offering to have a meeting with the folks whom you talk to who are going to have to implement if they do, sharing with them a draft of this, you know, letting them understand this is not voted on yet by the plenary. This is what we've come up with. I mean, if there's any huge red flags, let's know about that before the plenary. But I think more it's about how do you see this working in the agency and just engaging folks in getting excited. So it's just a recommendation for that type of meeting. Andrew, it looks like you're shaking your head. Yes, so that's great. And it's sort of going to be a little bit of a case study. What works well in terms of getting implementation after all this work. So that's all I wanted to say.
Thank you.
Absolutely,
so much.
Hy. Amen. Amen to that.
Great. Thank you all. I wish you a wonderful weekend.
Okay, bye-bye.
Thank you, Nadine.